Well, we're now going to talk about, that's going to be, a lot of our presentation is going to be what we mean by it and how to do it. We're now going to deal with what happens when someone dies. Everything in an estate goes through what I call the estate settlement cost funnel. There are 4 types of expenses that come out. The very first one is administrative expenses. You remember that administrative dragon? That's what we're talking about there. Now, the administrative issues raise 3 questions in my mind. 1, which administrative rules will apply? 2, how many different administrative rules will apply? And 3, where do you put your family in this process? A second expense to come out is going to be probate expenses. Now notice that the probate is in red, not green. The reason is you're always going to have administrative issues to deal with, but avoiding probate is possible with the trust. Then there are creditor and predator issues, and I sometimes use those terms interchangeably, but basically predators are people who would sue you to get money. Creditors are people you already owe money to. If a creditor wins a lawsuit, if a predator wins a lawsuit, they become a creditor. So you may have to deal with those, but not always. Then there are tax issues. Now, not everybody has to deal with tax dragons, but some people do. Now, just note, I'm not going to talk about this much today, but if the Form 706 is needed, and that's the estate tax return, administrative costs are going to increase considerably. Now, there are only 4 ways that assets pass. Read these left to right. The very first thing we look at is it owned jointly with right of survivorship? If so, it passes directly to 1 or more individual survivors. If it doesn't pass by right of survivorship, the next thing we look at on each asset is, does it have some kind of beneficiary designation, like life insurance, annuities, retirement plans, or a pay on death designation, or transfer on death designation. These typically are called passing by contract. I call it planning by the box. I call it that because there's a box that says, if something happens to you, where do you want these assets to go? And whatever you put in the box dictates what will happen. If you put an individual's name in the box, it's going to pass directly to that individual. And at that point, you will be playing by the same rules as right of survivorship. Now, that seems very simple, but in fact, I'm going to show you it can be very complicated. You lose control over what happens with these 2 methods of passing assets, and both of them blow any tax planning you may have done. Now, if the assets don't pass by contract, the next question is, are they owned by a trust? If so, they pass according to the trust terms. If it isn't owned by a trust, we only have one thing left, our catch-all box. That means it's owned by an individual, and that means it's going to go through probate. If it goes through probate, it's controlled by the will or intestate succession. If you don't know, intestate succession is the will that our state legislature has graciously written for you in case your will is not valid or you didn't do one. Now, if we've done a trust-based plan, we still have a will. It's called a pour-over will, and it pays assets to the trust so that the trust terms control the distribution. Now let's go back to the box. You can name the trust in the box as a beneficiary or TOD. We don't recommend the TOD for reasons I'll show you in a minute, but that allows the trust to control the distribution of those assets. Now, the box also, you can name the probate estate, but I drew a dotted line there because it's also the catch-all in case everything else goes wrong with the box, those assets go to the probate estate. Now, all of these assets get assets to beneficiaries. but they are not equal in the way they do it. So let's take a look at the administrative rules. You remember a while ago I said, how many different rules apply? We'll take a look at this. I think you'll find this eye-opening. You always have to look at case law, banking regulations, the Internal Revenue Code, and the Treasury regulations. With right of survivorship and beneficiary designations, they have one common set of rules. And in each state where there's an owner, a survivor, a beneficiary, or where assets are located, you're going to have these rules come into play. Also note that under the Internal Revenue Code, there are special bad tax rules that apply to these types of assets. Other laws that will come into play in each state, the estates are the probate code, the property code, the insurance code, and the family code. Now, if it's a trust-based plan, then all the assets will be controlled by one state's trust code. And if it's a Texas trust, the Texas code. With individual assets, in each state where you own a real property interest, you have to go through probate. And there you look at the estates or probate code or the property code. And there might be other laws that come into play. Now, one of the reasons we encourage people to get your assets aligned with the trust, you can look at those three boxes on the bottom and see it's a whole lot easier to play by one set of rules than multiple sets of rules. And we're going to show you a case where multiple states got involved and truly created a fiasco. So overusing right of survivorship and beneficiary designations can be disastrous for trust-based planning. In fact, some people say that those are the poor man's will. I'm just going to tell you, they're a poor will. Now, probate is not the problem. Some of this may sound familiar to you. The problem is a person is unable to sign documents to transfer assets. I don't know how they can vote when they're dead, but we cannot get dead people to sign documents. Probate solves the problem by having a judge authorize a substitute signature. If you're thinking, didn't we just hear this in guardianship? Yes, you did. There's a lot of similarities between probate and guardianship. Probate is one way and frequently the only solution to the problem. Is it the best solution to the problem? Well, let's define what probate means. The technical definition means to prove up the will. So one thing you should know, if you have a will-based plan, your will has to go to court. The layman's definition is the court-supervised transfer of assets for someone who has died. People want to know two things. How much does probate cost and how long does it take? Well, any firm who will answer those questions for you over the phone and give you a straight answer will lie to you about other things. Nobody knows. It's not possible, as I'll show you. Now, if you really understood the process, here's what you should ask. Who gets paid first and who controls the process? So let's take a look at what the Texas code says. The very first people paid are funeral and last illness of up to $15,000 each if the court approves. Now, when you see a phrase that says if the court approves, you should understand that courts approve things because lawyers go and petition the court and sometimes argue before the court. That can be an expensive way to do things, and it also shows that the outcome is not certain. Next comes a family allowance for up to 1 year if there are qualifying family members. Not going to get into that issue today, but I am going to talk about our favorite part, the cost of administration, because you'll see that's where attorneys get paid. Now, I'm kind of kidding, because the truth is we don't have to take a case until we've been paid. We only let the funeral directors and hospitals think they're ahead of us. But court costs, executor fees, preserving safekeeping and managing the estate, and unpaid guardianship fees, secured claims and tax liens. unpaid child support and interest, taxes, penalties, and interest. And I can hear y'all cheering. Yes, that's the IRS in Texas, number 6 on the list. Then comes the cost of confinement. If a person was in jail or prison, the state has a claim against the estate for the costs. Then repayment of medical assistance if they were on something like Medicaid. Then other claims. Now I'm going to give you an example of a case we had. We were doing a probate for a guy who owned a rental property. He had signed the rental contract and he died during the renter's first month. Well, the renter did not pay rent going forward. He said, hey, I'm supposed to pay John Doe, but he's dead. I will write a check to the estate of John Doe as soon as y'all give me the authority to write that check. Well, the John Doe's kids had to pay for the maintenance, they had to pay for repairs, they had to pay taxes, and they didn't have any revenue to cover that. It took over a year to get to the hearing where they had an estate created so the renter could write a check. And then what he offered to do, he offered to pay them in full, sign another lease for another year for the same rate, so they didn't get a chance to go up on the rate. And they didn't collect any interest. Well, that was very painful for the family. So people don't think about things like that when they own things like rental properties. Now, did you notice who's not on the list? It's the family. If you go through probate, your family will be last on the list. You remember a while ago I said, where do you put your family in this process? But not just where are they, but who controls the process? Well, I wish I could tell you that it was attorneys and courts, but it's not us. It's all these other people that we don't know how many of them might make claims. We don't know what it will take to resolve those claims. We don't know what it will cost to resolve those claims. There's a lot of unknowns. That's why I say nobody can tell you the cost of probate or how long it will take, because you've got several unknowns in that process. Probate is really a lawsuit you file against yourself at your own expense to protect your disgruntled heirs, your creditors, and your future lawsuit creditors. In my talking to clients, I find those aren't the people they're actually trying to protect. Well, let me give you an example of a case where we didn't have complete funding. Merlene set up a trust. She's got 3 children, Harry, Don, and Norma, and she died on a Sunday. 8 days later, her daughter Norma came to see us to administer the trust and discovered that she's going to have to go through probate because the only asset she put in it was her Texas homestead. Now, you may wonder what's with these people only putting their homestead in. That's because we do that for clients. Then they had to probate Merlene's will. 20% of the assets are going to pass through her will. The house here will not pass through the will, but the property in Wisconsin will. Now, the truth is, this is a little inaccurate because 20% of the estate was made up of the 2 pieces of property, and one of them won't go through probate. The other 80% passes by right of survivorship, transfer on death designations, and beneficiary designations, and they're all financial assets. Both sons are in second marriages, and Merlene did not care for either of her new daughters-in-law. So what happens? Well, let's take them one at a time. Norma lives here in Texas. It's her first marriage. She has kids. She's got no issues. The reason she's in a hurry to get this done is there's a very hot Texas real estate market. In fact, I'll tell you how hot. She put her home on the market on a Thursday afternoon, a little after 5, and by Monday, they had 7 offers, 6 of them above asking price. Now, she can sell the Texas real estate right now, but she can't sell the Wisconsin real estate until after the Texas probate, and then they're going to have to open an ancillary Wisconsin probate. 80% of her 1/3 she gets outright within a month, and that sounds good, but it offers her no asset protection and no divorce protection. And divorce has been an issue in that family. So while she believes her marriage to be good, she realizes she does have some risk of that. Now, Harry, he's in a second marriage. He's got minor kids from prior to the marriage, and he lives in Illinois. Now, Norma came to see us on Monday. On Tuesday, she brought her package back, and we told her that if she would get it back to us, we would have it ready to sign and go file with the court within 48 hours. She was highly motivated to get this done. Well, we called her on Thursday to have her come in and sign, but she never answered our call. That's because the next morning, she got the word that her brother Harry died of a heart attack 10 days after his mother. Now, when we finally talked to her, let's look at 80% of his 1/3 and see what happens. Well, right of survivorship assets vest within 5 days. That's true both in Illinois and Texas. He lived 10 days after mom. That's vested in him. It's his. It's now going to pass by his plan, not by Merlene's plan. Beneficiary designations vest immediately. If he survives, it's his. Doesn't matter if he dies a second later. Then he's got a simple will with his new wife. Everything that vested in him is going to go to her. That's 80% of the estate going to someone Merlene did not even like. What about Harry's kids? Well, he and his wife had done this simple will. They just hadn't gotten around to good planning yet. And what a disaster. Now, 20% from the will, he did not survive the 30-day period. Therefore, under the will, he is treated as though he predeceased his mother. That means that part is going to go to his kids. Also, the Texas real estate will go to his kids. Again, that total was about 20%. Now, under the trust, we've got provisions for what happens to the kids, but from the Wisconsin property, those kids are going to get that when they turn 18. They're going to have a real nice car, but not as much money for college, and especially since 80% of it isn't even going to them. They're going to have a guardianship in Illinois, by the way, and didn't that guardianship we talked about a while ago sound like a lot of fun? Merlene loses control of 100% other than the homestead. You remember I talked about how you lose control with right of survivorship and beneficiary designations? She set up a trust to control the assets, but then pass the assets a different way. That's what I mean by control. Now, Don's story, when Norma came to see us, she had just dropped Don and his family off at the airport for them to fly home to Wisconsin. He's also in a second marriage. He has adult kids from prior to the marriage. Now, Don gets home, and he's got a message from the bank that right of survivorship and TODs have paid. He needs to come in and open a new account. So he let the bank know he would be there the next morning. This is on Tuesday morning. Now, Tuesday, he receives divorce papers and spends the day finding a divorce lawyer. What happens on Wednesday? Surprisingly, when I ask people this, they forget. His brother Harry died. So, can you see where Don may have been a little stressed out? That will explain what he did next. He put his inheritance in a joint account with the wife who's suing him for the divorce so he can go to the funeral. I could not believe that happened, but that is what he did. Now, his wife was not the kind to take the assets out. She could have, but she didn't. However, under Wisconsin family law, she's entitled to 1/3 of it. Merlene lost control of 1/6 of what was going to Don. Do you see how right of survivorship, beneficiary designations, and TOD cause a loss of control? Hopefully, this will illustrate it pretty clearly for you. Now, what could her trust have done if all the assets were properly aligned? And that's sometimes called fully funding the trust. Well, all the assets passed by the trust terms are more favorable to everyone. It avoids probate in Texas and Wisconsin. Norma's would go to all of hers would go to her. It would be protected from any existing creditors, future lawsuits, and divorce. Harry's would have gone all to his children. That would be Marlene's grandchildren. It would have avoided guardianship there, 2 probates. It would provide for their college, protect them from existing creditors, future lawsuits, and divorce. Don's would have gone all to him. It would have protected Don from existing creditors, future lawsuits, and divorce. His wife would not have been entitled to 1 dime. Instead, only the homestead passed by these rules.